Hello, my name is Robin Miller. I am Chief Deputy Superintendent of Public Instruction at the Oklahoma State Department of Education. This Engage session is Stopping Sexual Violence in Public Schools. The focus will be on the new Office of Civil Rights Initiative and new regulations. In May, the U.S. Department of Ed released its final rule under Title IX, sex-based discrimination. The new regulation comes after years of research, deliberation, and feedback from survivors, advocates, falsely accused students, school administrators, Title IX coordinators, and many other people, including over 124,000 public comments. The new rule is effective August the 14th of 2020. Part of the strengthened protections relate to students K-12 and college who lost access to education when their schools inadequately responded. The new regulation requires schools to act in meaningful ways to support survivors of sexual misconduct without sacrificing important safeguards to ensure a fair and transparent process. In addition, the new regulation requires schools to respond appropriately when they learn of sexual harassment in their school programs and activities, between students and employees, and between employees and other employees. Before now, schools were subject to guidance documents, but now this protection is embedded in federal regulation. Key provisions of the U.S. Department of Education's new Title IX regulation include the definition of sexual harassment to include sexual assault, dating violence, domestic violence, and stalking as unlawful discrimination on the basis of sex. Schools must use this new definition for Title IX purposes. For the first time, the Office of Civil Rights defines a single instance of sexual harassment, previously defined as sufficiently severe or pervasive to be covered under Title IX. No longer will the Office of Civil Rights recognize the severe and pervasive threshold when evaluating Title IX protection. Additional provisions include schools' responsibilities when they learn someone is alleged to be a victim of sexual harassment. Specifically, that schools will promptly contact the person and inform them of their right to request supportive measures, whether that person decides to file a formal complaint or not. Schools should also consider alleged victims' decision and offer appropriate supportive measures under the circumstances. Explain to complainants that they have an option and a process for filing a formal complaint. School officials should never pressure an individual to file formal complaint or to participate in grievance processes. And similarly, never pressure to not file formal complaint or participate in grievance procedures, otherwise known as complainant autonomy. And lastly, school officials should investigate every formal complaint. The rule requires Title IX coordinators be designated and have authority to carry out the role. The main responsibility is to effectively implement supportive measures and remedies for victims of sexual harassment. The rule allows anyone, not just the victim, to report sexual harassment. Title IX coordinators must be known to the public by name, title, contact information. The provision requires schools to select one of two standards of evidence: the preponderance of the evidence standard or the clear and convincing evidence standard, and to apply the selected standard evenly to proceedings for all students and employees, including faculty. Additional key provisions include protection of students and faculty by prohibiting schools from using Title IX in a manner that deprives students and faculty of rights guaranteed by the First Amendment. Title IX coordinator training has expanded to include this new definition of sexual harassment, the scope of protections, prevention of irrelevant questioning, and technology. Upon formal complaint filing, requirements for hearings have also been defined. Every institution must provide live hearings for Title IX grievance proceedings. A trained hearing officer must oversee the hearing and exclude any question or evidence deemed to be irrelevant. The parties' advisors, not the parties themselves, must be allowed to cross-examine witnesses and the other party. At either party's request, the institution must provide for the entire hearing to be conducted with the parties in separate rooms, with parties able to see and hear each other in real time. Any party or witness may be allowed to participate in the hearing remotely, and the institution must record all hearings, even if the hearing is in person. It is evident that there are challenges to meet these hearing requirements, including institutions having technology to conduct and record live hearings, as well as arrangement of space in separate rooms and witness remote access. Ensuring software use, such as Zoom, has adequate security protocols as another challenge. In addition to technology, schools must recruit and train advisors and hearing officers on the Title IX hearing requirements and the school's own rules and procedures. An identified hearing officer must decide whether a question is relevant before it is answered. The new rule doesn't define what is relevant other than to exclude certain types of evidence. For example, a person's treatment record, privileged information, possibly questions about the complainant's sexual predisposition or prior sexual behavior. This is often called the rape shield protection. This hearing officer requirement may narrow the pool of your employees willing to serve. Hiring external hearing officers will conserve internal resources and may reduce claims of bias or conflict of interest. Extensive training for Title IX hearing rules, schools' conduct code, the standard of proof, and technology to be used is imperative. It is still uncertain and unclear as to the new rule if parties request a hearing officer can rule in advance on whether certain categories of evidence will be excluded or permitted in order to reduce question-by-question rulings on relevance. And while the rules permit cross-examination on credibility issues, it isn't clear how much hearing officers can limit the examination to protect witnesses from being harassed or intimidated. Institutions will also have to develop mechanisms to deal with party advisors who try to circumvent hearing officers' relevance rulings or who become unruly or uncivil during a hearing. Again, this new regulation goes into effect August 14th of 2020. If you have questions on this new regulation or on any Title IX regulation or process, please reach out. My contact information is here, Robin Miller, sde.ok.gov, as well as our General Counsel's contact information, Mr. Brad Clark. Thank you.